from Sterling Bank now.
Thank you, Your Honor. Your Honor, very little, virtually nothing of what counsel just said makes any sense.
I know it doesn't. I know it doesn't make any sense, but if he says that the signatures, these two signatures that are not witnessed and not notarized, are not those of his client, do I have any choice but to deny summary disposition and let a jury decide whose signatures those are?
No, Your Honor, that allegation I find particularly disturbing, okay? We're over a year into this case. That document has been in his and his client's possession since then. It wasn't just during the deposition that they saw it. Also,
Produced to them.
they've had it since the beginning of the case. It was attached to their initial pleadings.
It was
It's
attached to
part
their
of the
pleadings.
mortgage, yes.
I'm sorry, wait. Who did the plaintiffs also had possession of that document before the case was started?
Absolutely. They've had possession of all the loan documents since
You said it was attached to the complaint?
I believe it was attached to the original
I don't have the
complaint, or the
complaint here
amended
because the file's so big.
So, but nonetheless, we have this allegation of a forgery with no evidence. Not one witness has said it's a forgery until this affidavit was submitted. I attached their entire deposition transcripts. Not once in those deposition transcripts did they say it was forged. Not one time. He can't point to a place in there
He
where
said
they
that they said that it wasn't their signatures.
They did not say that. I read the deposition transcripts when I got into this case. If he can point to where they said that in the deposition and show that I've missed that, then I'll apologize to the court. But I didn't see it. I read it and I attached it to my supplemental brief. The first I saw was in the affidavit that came a few days after they filed their motion for leave to amend the complaint. Okay, so they make this allegation 8 years after these loan documents were signed in 2006.
Well, if they truly were forged,
There's zero evidence of that, Your Honor. They haven't deposed anyone from the bank. They don't have a handwriting
I think
expert.
that's what he wants to do now.
Well, if he complains that there's no notarization on it. There's no notarization on the note, the promissory note, which actually references 2 mortgages.
And I challenged him on that. I agree that I don't believe there's any legal requirement that it be notarized or witnessed. That's something that the bank would do for its own protection, but if they don't do it, it doesn't make it necessarily invalid. My problem is that if he says those are not his client's signatures, then what choice do I have but to send it to a jury?
I think you have a lot of choice, Your Honor. This is something which, if they were going to allege it, should have been alleged a year ago. First of all, let's look at the timing of when this comes out. I filed a motion to dismiss this
Can you show me
case
what this was attached?
because I find it very suspect that the day I file a motion to dismiss, because this is clearly barred by the 5-year statute of limitations, I get this affidavit on my desk saying, "Oh, we just noticed for the first time that these are a forgery." Well, the plaintiff had it after closing, so I mean, let me put it to you this way.
Do you have a response to a production request that you submitted it?
No,
that you gave it to
there was
them,
no
or?
written discovery.
Okay, so you don't have anything like that.
No.
All right.
All I can say is
The reason that you say that he had it before he filed the complaint is because he had it at the closing.
well, he references the mortgage, and it's part of the mortgage.
Okay.
I mean, I suppose we
All
have
right.
this
Well,
allegation
You're sending me on a
now.
wild goose chase looking
So,
through this.
I don't want to do that. I mean, I can get to the bottom of when he actually had it or when he didn't have it. He doesn't, there, nowhere in the record, nowhere, he comes up here and he says, "Oh, my clients didn't have it till this and that." Show me in the deposition transcript, show me in the affidavit when he got it. It doesn't even say there. His wife, Teresa, doesn't submit an affidavit or even talk about it in her deposition. So you look at the signatures, they're virtually identical. I attached several comparisons from the loan documents that came out of the Chase file.
I looked at them all. It looks like the same signature to me.
So, frankly, Your Honor, I think it's wrong. 1 year in litigation, when you know they got you, when you know your claims are barred by the statute of limitations, to throw one line in an affidavit, say those were forged, after you gave a deposition and had a chance to explain under oath that, no, that's not mine. He says they sat there at the deposition and they said, those are not my signatures. Show me in the testimony where that is. I mean, it's not there. It's simply not there. These are made up allegations that he got his client to put in a sworn affidavit, which I find very, very disturbing. And if we have to do discovery on this, I am going to push that issue as far as we can go, right to the Washtenaw County Prosecutor's Office. That's perjury. And he got his client mixed up in this.
Mr. Fair.
One thing Mr. Fair overlooked is not in the mortgage, in the promissory note, the document separate from the mortgage. It actually references in there that 2 mortgages were signed. And that's a document his client signed. So when he says this is the only document that references this other mortgage, that's not true. That was signed. Now, maybe they didn't know what they were signing. I'll give him that. Oftentimes, borrowers sign loan documents. Sure. I mean, that happens all the time.
Everything that's put in front of them.
Absolutely. But to say that somebody actually went in there and forged that document is a very, very bold allegation to make with 0 evidence to back it up.
Well, you told me this was attached to his complaint, too. I just want to know, when did he have it?
Well, why don't we ask Mr. Fair? Because it actually...
He says he never saw it until the deposition.
I don't know that it was even discussed at the deposition.
Well, that's how we found out about it.
Where? Where in the deposition? It's not even an exhibit to the deposition,
Okay,
as far as I know.
Well,
So...
as you know, in a motion for summary disposition, I have to give the benefit of every doubt to the non-moving party. You can't tell me when he got the document. He says he didn't get it until the deposition. He says his client didn't sign it. That's not their signatures. And I have no choice but to deny the motion for summary disposition and allow the motion to amend.
The Sterling motion?
Yes, the Sterling motion.
If I may, that wasn't even up for hearing today. And that was based
His
on...
motion to amend the complaint
His motion to amend is. And that doesn't address anything in my motion, which is based on the statute of limitations. He had 5 years to challenge that foreclosure, and he didn't do it until the 6th year. That issue hasn't come up. There's no way around it, even if you accept every allegation that he makes as true. They had 5 years to challenge this foreclosure, and they did not do it. There's nothing to toll it. The accrual was when the foreclosure sale happened.
How about that, Mr. Fair? Is he entitled to the benefit of the discovery rule?
I think the statute that applies is a statute of repose. There's no tolling it. It says 5 years from the date of the sale, and that's that. They had 5 years to challenge this.
And what was the date of the sale?
September something 2007. I believe September 20. Yes, September 20th.
And Mr.
Your
Fair?
Honor, if I may just say something. Attached to their amended complaint, it wasn't the mortgage, okay? It was the sheriff's deed from the foreclosure sale, which references the mortgage that we're talking about.
I know,
Okay,
but under his view of the facts, the addendum, or whatever it was called, was never a part of the mortgage until after the mortgage had. So you just
agree.
have to go with that. My
I agree.
obligation is to give him the benefit of every doubt.
But if we're going to give him the benefit of the doubt, he got a sheriff's deed. He obviously knew there was a mortgage that Sterling had on that property. Why are these allegations coming up now? And why didn't they come up in that amended complaint? He knew Sterling foreclosed a mortgage. He knew Sterling, it's identified in the foreclosure by advertisement that there's a mortgage there. And yet, so if he felt that there was no mortgage that existed that Sterling Bank held on that property, why wasn't that in the amended complaint that he filed and which is operative now in this case? And the reason is because he knows that the challenge to that sale is untimely. He knows, he has my motion. He's had it for several weeks. The day he got that motion, comes out for the very first time claiming that it's forged. Why? Because he has nothing else he can possibly say. Also, if we look at his fraud count, there's no fraud pled. There's no false representation that his clients relied on at all. If the fraud count is actually examined line by line, there's not a single misrepresentation stated in there. He really has zero evidence other than one line of an affidavit that comes after his clients gave extensive depositions and didn't even mention this. This is dreamed up stuff. This and I'll be happy to take discovery on it. And if Your Honor is inclined to let this go forward, which I don't think we should, if anything, this is dilatory, this is late. These are things that if they know them now, there's no reason that they couldn't have known them at the beginning. He knew Sterling foreclosed a mortgage, and if he felt that mortgage didn't exist, that there was no Sterling mortgage on that property, why wasn't that in the amended complaint? This is dreamed up.
Your Honor, counsel was not at the deposition.
I read the
No,
depositions.
but you weren't at the deposition. Brother counsel was at the deposition. There was another attorney representing Sterling Bank. I sat down with the two of them, and I told them at that time that we're going to be amending the case because of the fraud. And we also talked about other ways of settling the case by way of loan modification. So he's talking about something that he wasn't a part of. Now, brother counsel was there. Brother counsel knows that I told him specifically, both he and the attorney for the bank, that based upon what I saw here, I walked through with them the allegations that are in my motion to amend the complaint. It's not anything new. They knew about it right after the deposition. Brother counsel knows that. What I explained it to him. Counsel here was not there. He's new to the case.
If we're going to go outside the record and talk about hearsay conversations between attorneys,
No,
I got
I'm
a
not-
couple interesting
I'm not
conversations.
interested.
I didn't
I'm
think
not
so.
interested in that. Based on the statute of limitations, I'm going to find that I'm granting summary disposition on the motion to amend the complaint. I agree with the defense that if the plaintiffs believed that there never was a valid mortgage of any sort by Sterling on that property, that was clear to them at least a year ago when they learned that the property had been foreclosed, and they hadn't pled that there wasn't a valid mortgage. They pled that that Sterling didn't follow the proper procedures in the foreclosure.
Thank you, Your Honor. So we'll do an order under the
that-
7-day rule.
So I'm denying the motion for leave to amend, and I'm granting summary disposition
For Sterling also?
for Sterling. Yes.
Thank you, Your Honor.
Counsel, do you need this timeline back?
I can, yes, please.